Lesson 3, Understanding Contracts and Escrow, our terminology review. We talked about acceptance of contracts. That's really what creates the contract. It's not just the other party accepting your offer. Okay, that's important, but you have to be notified that that the offer was accepted, because you have the ability to revoke your offer up until the time you've been notified of the other party's acceptance. Accord and satisfaction, we don't use that in Illinois. Adequate consideration, again, we need to have something of value that each party gets to bind contracts, sometimes just called consideration. Anticipatory repudiation, when one party to a contract informs the other before, let's say, closing, that he or she doesn't intend to perform as agreed, the other party can file a lawsuit for breach of contract without making any other offer. In other words, once you've been notified that they had no intention of going through with the contract, you can actually file for the default in a court. Assignment, talked about that. That's where you assign your rights in a contract to somebody else. I think we gave the example of a commercial tenant assigns the rest of his commercial lease to another commercial tenant, and then he goes out and gets larger space. Bilateral contract, again, two parties are making promises. Buyer agency is an agreement between a real estate broker and a real estate agent to represent a real estate buyer. So buyer agency would work where we have a written agreement called the buyer agency agreement, and I'm your managing broker. So you bring me that buyer agency agreement, and at the very bottom, I will then designate you as the agent to represent the buyer. Okay, so in a buyer agency agreement, it's where we as a company then are going to sign an agreement with a buyer, but when we sign that agreement in that buyer agency, I'm going to identify you as the agent. So even though I, as the managing broker, as the real estate office, have the contract, the contractual obligation between buyer and the office, I designate you as the agent to represent the buyer. That way, I'm not going to be involved in any agency relationships. Cancellation, that's where you can terminate a contract, and usually with cancellation between the parties, that's kind of not desirable always, because with cancellation, you're going to lose your earnest money, Mr. Buyer. Commingling, illegally mixing those escrow funds. Remember when in our office, with any of our listings that we have in our office will be holding the earnest money, and where we hold it is we hold it at a local bank in an escrow account that we have there. And that money is not to ever be commingled with the managing broker's personal funds, nor is it to be commingled with the office funds. Okay, it's set there for behalf of protection of all the parties, seller and buyer. Compensatory damages, again, those are damages over and above liquidated damages that the court can award. Liquidated damages are stated in a contract. Both parties know exactly what they're going to be, and the court knows what liquidated damages are going to be. But compensatory damages can be any amount that a court wants to award, over and above it. Over and above liquidated damages. Consideration, talked about that. Contemporaneous offers, again, you have, if you are going to represent two of your buyer clients on the same property, you have to have them agree to it. They typically won't, but you have to have them sign and agree to under the notice of contemporaneous offers in order to do it. Contingency, this is usually a provision in a contract that makes the parties' rights and obligations dependent on the occurrence, sometimes non-occurrence, of a particular event. Like contingency might be a financing contingency. Our contract is contingent upon me, buyer, getting the financing necessary to purchase your property. If I don't get the financing within a reasonable period of time, I can walk away. The contract just dissolves and I get all my money back. Okay. So financing contingency is almost part and parcel of most real estate transactions. Conversion, that's when you take earnest money and you convert it to yourself. Okay. It's commingling is when you put it together with your accounts. Conversion is when you take it out and you spend it. Counteroffer, again, that's part of our meeting of the minds. One party makes an offer, the other party accepts it. Okay, or they make a counteroffer, and then we have counteroffers going back and forth between the parties until they reach agreement and until they reach the meeting of the minds. Earnest money deposit, money they say is their good faith to bind the contract, if you will, and I suppose you can use that, but we know that it's not the real purpose for earnest money, but it does show good faith, and it also means the buyer's got some skin in the game, so he just can't capriciously walk out the door after he's negotiating on 3 or 4 properties with no earnest money. He could just walk away from any of them at any time. So it makes the buyer think twice before engaging in maybe frivolous negotiations. Escrow account, that's the account where we hold our earnest money. Escrow monies, by the way, can be earnest monies, can go in your escrow account, and so can security deposits. So if you're leasing property, you would have, as a real estate office leasing property, you would have escrow accounts where you would put any of the security deposits that your tenants have for your landlord clients. Exclusive brokerage agreement, that's kind of like a buyer brokerage agreement. That's all that is. Exclusive right to sell, that's on the seller side. Exclusive right to sell is the type of listing contract that a seller would sign that basically says only your office has the right to sell this property during the term of our listing agreement. If I should walk off and sell it myself, or if maybe I should find another broker who finds a buyer for me, well, I guess good for me, except that I'm still going to have to pay a commission to you. So the exclusive right to sell says that you, as a real estate office, are the exclusive representative of that seller and will get paid if that property is sold by you, a real estate broker firm, or by the seller themselves. An executed contract basically means a completed contract. Usually we have executed contracts at closing. Up until that time, they're called executory contracts. So we have executory contracts while we're going through our negotiations. And then at the very end, where we have our closing, then we have an executed or completed contract. Good consideration, we've talked about that. Listing agreements, liquidated damages, meeting of the minds, minimum services. In Illinois, we do in our license law, we have a clause in our license law called minimum services. And so it's mandated by the state of Illinois that when you take a listing, you have to offer your seller minimum services. They don't care what your commission is or how you're getting paid, but whatever you do with your seller when you take a listing, you must offer them assistance in negotiating offers until you have a signed contract, or until all the contingencies are met or waived, or until it falls apart. And you answer all their questions relating to offers and counter offers. You also would be responsible for giving them any paperwork may be necessary. Maybe Mr. Seller doesn't realize that he's got to sign a property disclosure form, or maybe Mr. Seller doesn't realize there is uh, a an environmental form that has to be filled out, like lead-based paint or radon. Okay, so a lot of times sellers don't understand all of the documents involved. Well, you've got to help them through that process. In other words, you can't just take somebody's listing and sit on it and cross your fingers every day that somebody brings you a buyer that will be perfect buyer and that will assure you a sale. You've got to actually have to work for your commission. Uh, Again, novation. That's one way of legally terminating a contract and getting one party out. You simply get another party to step in your shoes and maybe and take over, in the transaction for you. So a new party comes in and sort of pushes you out of the way, which is what you want. Offers, counter offers, offerees are the people receiving the offer, offeror making the offer. Open listings, really, honestly, there really isn't a real thing called an open listing. We've termed them open listings, but there isn't a legal standing for a thing called an open listing. All an open listing basically means is that any brokerage firm in the area that brings the seller a buyer can receive the commission. But also the owner themselves can sell the property themselves. And that's where open listings can get brokers kind of in trouble, in that they can bring a buyer to a seller and the seller says, no thanks, I don't want to sell. And then a couple, 3 or 4 weeks later, they call up that buyer and do a deal with the buyer directly and sell the property. And you say, wait a minute, I introduced that buyer, I'm going to sue the seller. Courts don't recognize open listings, so you lose. So when you do an open listing, you're really risking that you're actually going to get paid, even if you do find a buyer for the property. So open listings, not good. Stay away from them. Parole evidence simply is oral evidence, not as good as written evidence, written contracts. Part performance. Sometimes a doctrine will allow an oral agreement to be enforced that should have been in writing if parties have already started and taken significant steps to complete the contract. Sometimes that can happen, rarely, and particularly almost never with sales contracts. Purchase agreement, we should just call that a sales contract. Okay, sales contracts, again, the obligation of a real estate broker or the extent of their authority with sales contracts is we can use pre-printed sales contracts with blanks in them, and we can fill them out as we negotiate between sellers and buyers. Okay, so your authority as far as preparing contracts is there, and it works very well. You just can't write the terms and conditions. You have to use pre-printed contracts. Just fill in blanks and cross things out that aren't applicable. Rejection, that's when somebody rejects an offer before it's accepted. Rescission, when a contract's terminated and each party gives anything acquired back. That's a way you can cancel a contract, Mr. Buyer, and get your earnest money back. Cancellation won't do that. It'll cancel the contract, but you'll lose your earnest money. Revocation, we've talked about. Severable, we've discussed that. Specific performance, again, that's where the court can make a seller sell or a buyer buy if there's a dispute under the contract. Statute of frauds, we talked about that a couple times. Tender we don't use. Time is of the essence. Everybody's got to move quickly. If they don't, if your failure to move quickly, it could result in a breach. And we've talked about unenforceable contracts. Again, a good example is it's not in writing. Unilateral contracts, only one person makes promises. Valid, void, voidable, we've discussed those. Okay, continue on to the key concept review for lesson 3.